Thank you. I would like to welcome our distinguished Dr. G.B. Reddy, who is former Dean of Osmania, and Dr. Alka, the Professor, Delhi University, and our Honorable Dr. Pradeep Kulshrestha, School of and faculty members and my dear students for joining this wonderful webinar. Dr. G.B. Reddy is a lawyer turned academician, studied BA, LLB and LLM Constitution Law at Osmania University and PG Diploma in Human Rights from University of Hyderabad. He obtained PhD in Law from Osmania University in 1999 on the topic Supreme Court and Judicial Activism, its contribution in specific areas of constitutional law after 1980. His area of specialization is constitutional law and he is LLM in judicial activism in PhD. He is specialized in the area of intellectual property as an independent researcher, publisher, and teacher. At present, he is member of Telangana State Legal Services Authority, chairman of Ethics Committee, Center for DNA Fingerprinting, Hyderabad. He is member of Academic Council of Nalsar University, Hyderabad. He is also Dean of Faculty of Law, Telangana University, and Satavahana University, Karimnagar since 2013. And he is also former Dean of Osmania University. Dr. Alka Chawla is PhD in Copyright from University of Delhi. She teaches intellectual property, administrative law, and jurisprudence. She wrote 2 books on copyright. Latest is published by LexisNexis, Law of Corporate Comparative 2013. She is also presented papers at various forums, namely WIPO, USPTO, FICCI, TERI, Swiss Institute of Comparative Law, Switzerland, George Washington University, USA, University of Edinburgh, Scotland, ESCP, and various judicial academies. That is your Chandigarh Judicial Academy, Delhi Judicial Academy, Orissa Judicial Academy, National Police Academy, National Academy of Customs, Excise and Narcotics, reported on counterfeiting and piracy for Organization for Economic Cooperation and Development, OECD Paris. Protection of intellectual property rights is vital to the development of a country. Companies and individuals can spend years and a fortune to product that is created, not if owners of intellectual property. So this declaration, please check कर लीजिए.
जी.
Or not if the owners of intellectual property are unable to ensure its action. Let's take a look at who's challenge here. And other IP were rampant, causing to IP with India's political, social, and economic evolution, protection of IPR is vital to ensure intellectual, cultural, and economic growth. The first patent law was introduced in India in 1856, which was followed by the Indian Patent Act of 1970. The first major step towards IPR protection came in 1995 when India joined the World Trade Organization and became a signatory to trade-related aspects of intellectual property rights agreement. This set minimum standards of intellectual property regulation by its members. And its protocol part now permit the filing, petition, and maintenance of trade rights in more than 90 countries. By India, instead of India is elected and currently challenges why the right to the court of rights and court cases that could run on for years. This is a sore point, particularly for large multinational corporations in areas like pharmaceuticals and agriculture. India. For example, on the United States State Representative Priority Watch List for poor protection of the rights of American companies, along with countries like China, Russia, Indonesia, Saudi Arabia, and Venezuela. Indian government to protect the interest in Indian citizens in some instances. For example, under the provision of compulsory licensing, the government can force the patent owner to or get someone else to mass produce an essential drug in an emergency. Another contentious clause is Section 3D of the Indian Patent Act, which prevents large pharma companies ever. सुदेश जी म्यूट कर दीजिए, अभी भी कुछ डिस्टरबेंस आ रहा है.
सर मैं कर रहा हूँ.
Prevents large pharma companies from ever giving or continuing the patent perpetuity by making minor changes in earlier patents. Now, without wasting any further time, people are patient to hear the today's distinguished speaker. Now, I request Dr. G.P. Reddy Garu to start his presentation to speak his valuable words, please. Over to Dr. G.P. Reddy Garu.
Thank you.
Welcome, sir.
Yeah.
Welcome,
Professor sir. The Dean School of Law, Sharda University, Professor R.P. Yadav, and my co-resource person, Professor Alka Chawla, other colleagues from different universities, dear researchers and friends. At the outset, I thank the Sharda University in general and my good friends over there in particular for giving me this opportunity to present some of my views on the intellectual property rights post-COVID 2019. Well, all of you are familiar with the various nuances of the intellectual property rights. And whenever we speak about the intellectual property, its creation, its management and exploitation, we always think that it is a kind of incentive given to the creators. There are various theories of protection of intellectual property. And for many of us, intellectual property is a source of generation of wealth. To recollect the statement of Lester C. Thoreau, who made, in fact, a contribution in the form of an article in Harvard Business Review way back in 1997. He said that the wealthiest man today is a knowledge worker as compared to an oil worker till then. He was referring to Bill Gates. So, intellectual property has become a means of, in fact, the enrichment, that is one. But the other important purposes include finding solutions to the existing problems and also, in fact, protecting the natural rights of the creators. This is one important aspect. And when we look at the National Intellectual Property Policy of 2016, there is a categorical mention about the stimulation of the creativity and innovation by the intellectual property for the benefit of all. That is very important, for the benefit of all. And COVID 2019 reminds us the necessity to use intellectual property for benefiting one and all in order to protect the public health from this pandemic. And another important aspect is that the present government at the center also is very keen to, in fact, to foster a new intellectual property culture, as can be seen from the statement given by Prime Minister Modi ji on the sidelines of Indian Science Congress 2020, when he said that we must innovate, patent, produce, and prosper. This is one important aspect. Now, during the last 6 months, many of us have been trying to grapple with the issue of intellectual property protection on the one hand, and again trying to explore an answer to the question whether intellectual property protection is going to be a kind of hindrance to, in fact, the measures to protect the public health. Here, I think we must use intellectual property as a means, as a source to protect the public health. Now, be that as it may, all the intellectual property rights may not be really relevant as far as COVID-19 is concerned. Some of them are more relevant, some of them may not be relevant at all. To my mind, it is the patent law which, in fact, plays a very important role, the kind of patent protection that is given to various kinds of inventions and sometimes even to the innovations that is going to be relevant today post-COVID. If you look at the various writings of people like Francis Gurry, the outgoing Director General of World Intellectual Property Organization, and many others, what they are trying to say is that intellectual property has to be protected. At the same time, its creation also must be incentivized and encouraged in order to meet the growing needs of the public, in order to protect them from this, COVID pandemic. This is one important aspect. Of course, this also gives us an opportunity to explore the possibilities of, exploiting the genetic resources and traditional knowledge. This is one area. Then also the Ayush system of the medicinal treatment, the Indian traditional indigenous system of the medical treatment. That is also one of the important aspects. And the basic question is this: whether pandemics like COVID-19 or before that, even SARS or MERS or many more, whether they lead to change in the policies, international as well as domestic policies, as far as the intellectual property protection is concerned. But I feel that the framers of these policies at the international level as well as national level, they have provided enough flexibilities in the existing laws and procedures to take care of the pandemics like this. For example, if you look at the TRIPS agreement, it categorically recognizes the power of the member states to take care of the public health. There are a number of provisions. Even the objectives of the TRIPS agreement also include the need to protect the public health. Then there are various ways and means contained throughout 70 plus provisions. This is one aspect. Added by that, we also have the Doha Declaration of November 14, 2001, where we have seen that even mighty countries, very powerful countries like United States of America, had come around and ultimately supported the need to issue compulsory licenses, as pointed out by Professor Yadav just now, compulsory licenses in order to protect public health. And India has succeeded in granting one such license, of course, not with regard to in an epidemic or pandemic like this, but with regard to a cancer treatment drug, which was patented by the Bayer company, which was ultimately compulsorily licensed to a Hyderabad-based NATCO Pharmaceutical Limited. Now, be that as it may, we have the national legislations pertaining to various kinds of intellectual property. Probably the, in fact, the Patents Act of 1970 plays an important role. This is one aspect. But apart from this, we also have the other enactments, like maybe the Biological Diversity Act to some extent, where the biological resources can be exploited in finding some kind of cure or, in fact, the treatment of pandemic like this. Now, be that as it may, the issue is this. When we look at the Patents Act 1970, we find that the statesmen of the day had already taken care of the public health concerns under this particular law while protecting the rights of the patentees. Take, for instance, Section 47 of the Patents Act. It categorically mentions about the conditions subject to which a patent can be granted. If you look at clause 4, it says that in case of any patent in respect of a medicine or drug, which may be imported by the government for the purpose merely of its own use or for distribution in any dispensary, hospital, so on and so forth, it points out the government's power to acquire such patented drug are, pharmaceutical for the purpose of distribution throughout the government hospitals and dispensaries. That is with regard to, access to vaccine, if at all it is developed. Similarly, when we look at the section 83 of the, in fact, Patents Act, which deals with the general principles relating to working of the patented inventions, one of the most important principle is this: the patents must be granted to ensure that they do not impede public health. So public health is of paramount importance even under section 83 of the Patents Act 1970. Similarly, we have the unique provision of declaration of health emergency, extreme urgency, and in the case of public non-commercial use, we have to look at section 92, which categorically mentions about certain diseases like AIDS, HIV, malaria, then even tuberculosis. Probably, I don't know whether COVID-19 will be added or not. It may not be added so soon, but still the central government has the power to declare such emergencies like national emergency, extreme emergency, then for the purpose of now public non-commercial use. That is in case of a drug is available. That is one issue. Similarly, with regard to import of the pharmaceutical product and the grant of compulsory license, also section 92A categorically mentions about it. Section 107 speaks about the defenses that can be taken in infringement of suits by the patentees. Parallel imports is one of the provisions. What I am trying to say is that we have number of flexibilities under the existing, in fact, IP legislation in India and also under the international instruments, especially under the patent law. Then let's look at some of the consequences of the COVID-19 pandemic. I pointed out that there is an increased research activity for vaccine. In Hyderabad, every second day, our chief minister says that, in fact, Hyderabad is going to be the place where vaccine is going to be invented. I sincerely hope that it's true. Now, the question is not as to get access to the medicine. It's not access to the vaccine, access to the cure, but the absence of any approved vaccine. So, in finding or inventing the vaccine, there must be a conducive environment which should be created by the government by encouraging those researchers and inventors, including individuals as well as the companies. That is one observation with regard to the increased research activity for vaccine. The second one is exploration of the indigenous medicines to treat COVID-19. Probably this is not something which can be easily dismissed by anyone. Allopathy, fine, it's a wonderful system of medicine, but at the same time, we have our own indigenous systems of medicine which can be explored to find a cure for such pandemic. That is another thing which is going on. The third one is many inventions are being made, many innovations are being made. We must have seen that a family of a migrant labor, in fact, it was using a transport mechanism made of some kind of, wheels taken from one device, body taken from other device, and where a bike is being driven like a car, because necessity is mother of all inventions. And we are coming across number of activities like this, like, the various inventions, most of them are rural, even urban as well. In research institutions also, we are coming across increased research activity, whether it is IITs or private organizations. And it is need-based. Probably nobody really, inventing them or making improvements to the existing ones only for the sake of exploitation as intellectual property rights. And here I might draw your attention to few of the significant inventions or innovations made recently. For example, high band. People say that, in fact, the COVID spreads with three things: men, that is mouth, eyes, and nose. So when people frequently touch these three things, there is every possibility of spread. Therefore, a wristband which was used to prevent the scratching and all, now it has been improvised to make a hygiene smart band by a company called Slightly Robo in US. Similarly, there is temperature checker. Temperature checker is also an improvement over one of the existing devices. We are coming across telemedicine, online learning, video learning apps, in fact, the e-commerce deliveries, then ventilators, masks, whatnot. Lot of activities taking place, which is driven by the necessity created by COVID-19. Then there are number of strategies which have to be adopted by the government, by the innovators, by the general public, and all the stakeholders. First one is to look from a policy perspective. You will find that there is a need to incentivize the inventions and innovations leading to fight COVID-19. I'm sorry to say that I haven't gone through all the, in fact, the proposals given by the finance minister, but I'm sure that there is something for the startups which are coming up with the COVID-19 related cure, treatment, or whatever, medicine. This is one important aspect. And such companies, individuals must be incentivized. This is one important aspect. And there should be more flexibility in terms of the rigid procedures also. Second one is about the administrative procedure. I had an occasion to look at some of the IP companies or IP firms leaders speaking about the steps to be taken in the IP offices the world over. You can refer to the WIPO COVID tracker, which refers to the practices which are being changed or which are going on in various parts of the world. So online mechanism is coming in the place of offline mechanism. This is also a good one. Then the third one is, this is more important, the other strategy. In India, in fact, the National Intellectual Property Policy of 2016 has deliberately ignored the second tier protection to the inventions, that is the protection to utility models. Probably having some kind of utility model or utility patent protection in times like this will definitely incentivize those people who are going for more and more different kinds of inventions and innovations. This is one important aspect. Probably a policy decision is needed. It can be taken only by the government at a different level. Similarly, compulsory license. Of course, if there is an existing drug or vaccine, one can think about compulsory license, especially when the patentee is refusing to grant any license voluntarily. But certainly, another attempt has to be made by the government after the NATCO Pharma's episode in situations like this. Government also can acquire patents or patented products for the purpose of distribution through various, in fact, government dispensaries. The Epidemic Act of 19th century probably can be better utilized for this purpose in the patents problems. Then similarly, revitalize the Ayush, maybe the traditional, TKDL, now traditional knowledge, digital library, and the Ayush, then GRTK, genetic resources in traditional knowledge, all of them have to be revitalized, relaunched, and maybe for them certain policy changes are required. Last point before I wind up is that let us remember the Doha Declaration of 2001, and let us remember what happened to United States. There was a threat of SARS. There was a proposed, in fact, an effective treatment in the form of ciprofloxacin, and they found that was available at a cost of around 30 rupees per unit in India, whereas it was around 900 rupees in United States of America. The same United States of America was really, which was opposing grant of compulsory license, for the first time conceded Doha Declaration is the result. And in fact, we need some such, in fact, leverages, flexibility in order to come out with more and more, inventions in the area of, COVID and the related treatment. So these are some of my stray thoughts, please. And I'll be happy to end here and listen to the other resource persons. I'll be online. Thank you all for giving a patient hearing. Thank you very much.
Thank you very much, Reddy Garu. We will be taking up question answers after the session is over.
Yeah.
Now I invite Dr. Alka Chawla, Associate Professor, Delhi University, to please express her views, please. Dr. Alka Chawla, I am audible to you?
Yes, just wait
Dr.
for.
Alka Chawla, I repeat.
Yes, you're audible to me.
Okay, madam. Thank you, madam. Thank you so much. Thank you.
Good morning to everyone. Thank you, Dr. Reddy, Dr. Yadav, Dr. Pradeep Kulshrestha, and Lipika. She was my student, so my special thanks to her.
Thank you, ma'am.
I feel privileged to speak on the relevance of IP, keeping in view the challenges posed by COVID-19 and how IPR is likely to be managed in the post-COVID era. Now, for all these stakeholders operating within the IP sector, it will be vital to ensure not only that the existing IPs remain protected, properly protected, but the innovation ecosystem also remains sound when the world finally recovers. Eventually, the national and the global responses to the crisis will determine how we face up to the challenges and convert them into opportunities, which I think is very important. I'm going to limit myself only to two sectors of IP relevance. The first one is patents and innovation for health. Secondly, brand protection and trade infringement. And thirdly, education and fair dealing provisions under copyright. Now, coming first to innovation for health. The main challenge at the present time is not only absence, as Dr. Reddy said, of approved vaccines, treatment, or cure of COVID-19, but also access to them. Can you see the presentation? Can you all see the presentation?
Yeah.
Yes, ma'am.
All right, thank you. The main focus of the government policy, as Dr. Reddy said, shall first be on supporting science and innovation, public-private partnership for research, funds for R&D, innovation and infringement, and access to technology. Now, in response to the access, the first task is to identify the barriers to access. My question today to the audience and to myself is, are IP rights inter alia acting as barrier or hurdle to India's fight against COVID? Let's take an example. Roche, as we all know, is a Swiss company, and it could not supply sufficient volume of diagnostic kits and withheld the present protected chemical formula for a reagent used for reaction-based test for COVID. Now, this apparently was the reason for delay in scaling up coronavirus test. Now, if you look at the situation, Roche is within its legal rights to withhold the IPR, but on the other hand, humanity at large has a right to health. The COVID pandemic has thus added a new complexity to the public health and trade discussions. In a recent article, Nobel laureate in economics, Joseph Stiglitz wrote, with the arrival of COVID-19, it is now obviously painful that such monopolization comes at the cost of human lives. Monopoly control over technology used in testing for the virus has hampered the rapid rollout of more testing kits. Now, at this time, at this kind of a situation, many academics are even suggesting applicability of Article 73 of TRIPS, not only with regard to compulsory licensing, but even with regard to security exceptions which have been given to industries. Now, the two debatable questions for interpretation involved there are, first, does the current pandemic constitute an emergency in international relations? And secondly, is importing COVID-19 treatment to address a country's own insufficient manufacturing capacity, I would say necessary for protecting the essential security interests? Now, this is a debatable question. But at the moment, the undisputed policy measures that are available in international and national IP is to manage and mitigate the emergencies and the catastrophes, including the provisions of the compulsory license. And we all know, and we've been told previously also, that we have a number of provisions dealing with it, especially Section 84, 92, and 92A of the Patent Act. Somebody is saying that the PPT is not visible. I don't know, I just saw. The world today is facing an unprecedented time of solidarity. That is something very fortunate in the face of adversity. Many corporations are pledging not to enforce their patents. Many are granting voluntary licenses to meet with ever-increasing demand. There are some who are suggesting to recognize patent pools for enabling the sharing of IP. The patent offices globally are taking up how best to address IP issues. In India, for example, IPO has extended all the due dates. As Dr. Reddy was mentioning, I would add on to it that WIPO has undertaken a number of measures. I hope you all would be knowing, but I would quickly tell you what are the steps taken up by WIPO. First of all, they've set up a clearinghouse or policy tracker, which provides information on measures undertaken by IP offices contributing to innovation. Secondly, the provision of a database which is called Patent Scope, with over 80 million technology disclosures, multilingual search capabilities, an automatic translation system, and a specially developed COVID-19 search and retrieval facility dedicated to enhancing access to technological information disclosed in published patents with regard to inventions relating to the detection, prevention, or treatment of COVID-19. Now, this invaluable source of technological intelligence is widely used by hundreds of thousands of scientific and technological institutions all over the world. Third thing what WIPO has done is that it is dealing with establishment of partnership with scientific, medical, and technical publishers, ARDI as it is called, which provides free online access to major scientific and technological journals to local not-for-profit institutions. In the least developed countries, the fourth thing, which is I think of importance, is the establishment of some 900 technology and innovation support centers worldwide to provide access to patent and scientific data and publications, ancillary facilities for researchers in least developed and developing and transitional economies. Now, this is with regard to patents. I would like to move on to brand protection and trademark infringement. We can have questions on patents later on. Can you see the presentation now?
Yes, ma'am.
Okay, you can. All right, coming to brand protection, with the outbreak of this novel coronavirus, there has been a sudden and a massive requirement of numerous medicines, ventilators, personal protection equipment, sanitizers, and so on and so forth. The healthcare category, LB the most important, is massively susceptible to counterfeiting and infringement. There have been numerous reports of counterfeiting of PPEs, hand sanitizers, face masks, etc., which has a direct impact not only on people suffering from ailments, but also on health of the frontline workers. That is the medical staff working day in and day out. More than 36 such premises have been identified by the government. Just to give you a few examples, a huge racket of hand sanitizers was caught by Hyderabad police right before the country-wide lockdown was imposed. Police in Bengaluru, they raided 2 premises in the city and they caught manufacturers selling thermometers without any labeling being sold at exorbitant prices. It has been estimated, we keep hearing across India, that industries are suffering an annual loss of approximately rupees 1 crore owing to such counterfeiting activities. And there is a significant apprehension that this figure may rise during the current conditions. Various commercial, after 20th April 2020, various commercial activities have been allowed as per the Ministry of Home Affairs notification. And the courts are taking up only urgent matters. These are the 2 things which have to be kept in mind. Why I'm saying so is this is basically for the industry, because it has become very imperative for the brands to ensure that there's a strict brand enforcement by being vigilant in respect of materials that may be deemed to be infringing. They have to take it up themselves. The employees of the various brands must immediately initiate what is called internal standard operating procedures for verifying any infringement of IP or counterfeit of products. So, for example, if you look at Amazon, what Amazon is doing is that they are using a number of tools to monitor IP infringement. For example, what they've done is that they have provided publicly an online form for right owners to report infringing listings. This can also include reports of trademark infringement, design patent infringement, and even utility patent infringement, which we don't have the provision here in India, but it is there in other countries. Amazon has been unveiling new programs aimed at boosting brand owners, anti-counterfeiting facilities. One such program is called Project Zero, which can be available to certain brand owners and allows them to remove infringing content from Amazon themselves. You know, from Amazon, the other industry can also take the clue. Another such program which has been taken up by Amazon is Amazon's transparency program. Now, this allows brand owners to apply unique codes to their products, which Amazon employees can scan in warehouses and customers can scan products they receive to ensure authenticity. These programs and others, they have a great potential to reduce sales of counterfeit products on Amazon and ensure that customers receive genuine products. Now, brands can also enter into mutual agreements and understandings with such online platforms, wherein the products are being supplied and they are exclusively procured by the online platforms from these verified vendors. So with regard to trademark infringement and counterfeiting, that's another issue which is coming up. I would like now to move to the third one, which is education. And I think all of us, most of the faculty which has joined, and people oldies like me are finding it very, very difficult to work on the online teaching. But we have put all our hard work, sincerity to get to students, not only visually giving lectures, but also writing lectures for them, writing notes for them. And it is for the first time, I think, the students are getting permanent lectures from the teachers, which is not going to probably help this generation, maybe the next one which is going to come. So I don't know how many students would now like to attend our classes now that they have all our notes and all our hard work there. Now, you know, most of these educational institutions, they're closed due to COVID-19 pandemic. But as I'm already saying, that the closure of the institution does not mean that we've stopped imparting education. Teachers in schools, universities, higher educations, they've all resorted to online teaching through platforms. Webinars are being organized like this, we are doing this one. Dissemination of information and knowledge is taking place. There is a general realization, not only in the education sector, but even in the industry sector, that working from home, hosting remote events such as video conferencing, webinars, moving towards paperless and cloud-based system, they're essential in the current environment, particularly when managing enforced remote working. Now, this is likely to drive a huge acceleration in digital adoption in the future also. This is a very, very challenging time for everybody, both emotionally and intellectually. I can say for myself, I found it very difficult because I don't find the reactions of my students while I'm giving a lecture. But from a practical perspective, one of the key challenges to this unprecedented and unexpected shift to online education will be addressing the copyright issues. It can be far easier to infringe copyright in the online environment than in the classroom, because digital technology facilitates the copying and sharing of learning materials, and learning activities that previously took place face-to-face are far more visible and open to scrutiny in a digital space. The Copyright Act, it's all for the educators that I'm saying, does give exclusive rights to the owners of the copyright, but it also has a huge provision which is called a fair dealing provision, that is section 52, which is I think running into 4 to 5 pages with clauses running, I think 42 to 44 clauses are given there, which tells you what is fair dealing. One of the clauses which is very important for the education sector in the pandemic times are section 52(1)(I), which says the reproduction of any work by a teacher or pupil in the course of instruction, or as a part of questions to be answered in examination, or in answers to questions, does not amount to infringement of copyright of the owner. Now, it is advisable, I think, for all teachers or any speaker on a webinar, whoever uses any material, whether it is text, image, sound, or video, they shall acknowledge the source from which one has taken it. Why I'm saying this is, though we have a fair dealing provision, but even then acknowledging is important, because once you're taking somebody's work, I think it's morally important to say from where it has come, and legally important, so that tomorrow you're not taken unaware by someone by bringing a copyright infringement suit against you. Because this is a law which is still evolving, it is still developing. So we still do not know how the courts are going to take up certain issues. Now, but at this time, I would appreciate, and it's appreciable, that many of the right holders, they have taken steps to make their works easily available to schools, universities, libraries, research institutions, and general public. And these steps include innovative licensing arrangements, free access to research related to COVID-19, free access to newspapers, media articles about COVID-19, free access to many educational texts, online learning platforms and ebooks, and free transmission of concerts, operas, and other cultural works. I thought I'll stop here. But if Dr. Pradeep and Dr. Yadav allow, I would like to say certain things on the entertainment also, though I had not included it in my PPT. Because, this is a topic which is very, it has created a very unique environment today, especially with the Indians, as they've become creative, especially during times of crisis like COVID pandemic. And we saw this even at the time of demonetization. People are sad, people are suffering, but when they're sitting at home, they're free, they're becoming highly creative, and they're creating a lot of copyrightable content, I would say. So do I have the permission to continue?
We are privileged. Madam, we are privileged to hear you.
All right, so I'll take probably 5 more minutes.
Please, ma'am.
As I said, that Indians have become highly creative, especially during the times of COVID pandemic. The digital content creators have increased in large numbers, and platforms to them are provided by apps like TikTok, YouTube, Instagram, Facebook, etc. Now, these platforms are providing space for content on one hand, but they're becoming breeders for copyright violations on the other. The most common content posted by people includes music, video clippings, songs, cover versions, not the technical sense, but versions of songs. There are, movie scenes which they pick up, and also they are picking up trademarks of others, and sometimes making fun, sometimes comparing it with others, which is in technical terms is called disparagement and comparative advertising, which is also infringement under trademark law. Both the TikTok and YouTube, they do have an IPR policy. But if you look at the IPR policy of TikTok, that's not very strong. But as far as the IPR policy of YouTube is concerned, that is quite a stringent policy which they have. But one thing which I want to make very clear is that they are not directly responsible for the content that users upload or, copyright violations. They have the responsibility to ensure copyright protection. For example, if you look at YouTube's policy, that includes copyright strikes, content ID system, copyright verification program. They have provided all these things. But it's very, very important for, the content providers not to violate the copyright law. TikTok, TikTok, for example, it uses music after taking license for video sharing. But very recently, there was a threat by the music companies who were, in fact, threatening to bring legal action against TikTok for violating the copyright of the music companies. So these platforms, on one hand, do have a policy, but on the other, sometimes they are themselves indulging into IPR violations. I would like to end my talk with some do's and don'ts for the content providers, which are increasing in large numbers nowadays. First of all, do not use too much of anyone's work. Especially when it comes to music, do not pick up the heart and soul of music, right? Now, heart and soul means the quantity may be less, but the quality is the heart and soul of music. Like, for example, selfie lele re. So just two words, selfie lele, that is the heart and soul of the song which is there. Secondly, if you're using substantially somebody's work, do take a license from the copyright owner, because otherwise you will land yourself into a problem. Third, sometimes what people do is they make something for one platform and they repost it on another platform. Let's take an example. You make something for TikTok. Now you are protected by TikTok IPR policy, and you're also protected there because TikTok has taken a license and it has got certain guidelines to which you've agreed to. But when you repost it on some other platform, it is not necessary. I'm not saying always, but it is not necessary at times. You may not be protected on that platform. So therefore, on one, you're not creating infringement, but another, there is an infringement of copyright which is taking place. Another thing which is very important is whenever you are making money out of someone's work, for sure there is copyright infringement which is taking place. So my advice to all of you is, please use common sense. Common sense when I say, whenever somebody creates a work, the creation of work is the property of that person. And if you take away the property of that person without the permission, you are committing theft. And theft is a crime for sure. So I would like to end by saying, stay safe, keep safe, use common sense, have fun, but do not commit crimes. Do not commit infringements. Thank you so much.
Thank you very much.
Thank you, sir. Sir, can we take up question answer session, please?
Yeah, please, sir.
Yeah, please.
There is one question, sir, from Vivek Shukla. How global technology transfer mechanism help to come up with new vaccines soon? Shall I repeat, sir, once more?
To whom this question is addressed?
They have not addressed to anybody in particular, but any of the speakers.
I would just like to say one thing, then Dr. Reddy can add on to it. You see, research is basically, you have certain material already which is present and you're working on it. So sometimes what happens is technology transfer, what it basically means is somebody already has some technology and you need to work on it to go further for improving. You need to take the permission of the person who already has a right on that technology. If that person still has the patent right and it has not gone into public domain, you will have to take the permission and then go further.
Yeah, I agree with her. I agree with her. Because in fact, technology transfer is one of the objectives of the patent protection. If we look at the objectives of the TRIPS agreement and section 83 of the Patents Act also, it's the same thing. It's not necessary that technology transfer takes place only through the agreements, but even patent, in fact, also enables the technology transfer from private domain to public domain, subject to certain protections during the period of patent.
So there is another question from Dino Purnamodan. GM crops are not allowed in India. Do you think post-COVID, India should open up these restrictions to meet the needs of people in terms of their food and agricultural outputs?
Probably, yeah, if I may answer that, probably I think, we can only postpone opening of such, a possibility. We can't totally prevent the GM crops, entering India. Already, I think Gene Tech and other companies, they have already filed cases before the Supreme Court of India, and under the Plant Varieties Act, now they are coming in, in a large scale. Maybe there will be increased activity as far as GM crops are concerned, and I think subject to the medical and health considerations, they must be welcome.
Thank you so much, sir. Sir, there is another question from Mr. Saurabh Raj. Post-COVID, the economy is expected to be in bad shape and government will be under pressure to revive it. What if government joins private plus other players to exploit the people suffering? Is there any check on it?
Can I
Absolutely
answer
not.
that question?
Yeah,
I think
please.
are we not being very unreasonable in asking that question? I think one should not doubt the intentions of the government and the people. And we have seen during these pandemic times the kind of solidarity which has been even shown by the private sector people, by industry, as they're sharing their even protected patents at times. So I don't think so.
If I may
There
add,
is, yes, sir.
Professor Yadav, just one sentence.
Yes,
Honestly
sir, please
speaking,
go, sir.
yeah, there is no legal impediment for joining of hands by the public sector and private sector. And in fact, if you followed the recent developments, the National Serum Institute, which is a government concern, now it is collaborating with a private university elsewhere, probably United Kingdom, in developing this, the vaccine. We only hope that it's going to be successful. So public-private partnership is the need of the hour. That's what I feel.
On that ground, yes, I agree with you. But to say that to increase the suffering of the people, I think that's something
Not
wrong.
to increase, ma'am. It is the other way around.
No, that's what I'm saying. No, the question said so. So public-private partnership is very, very important. And that is basically, it's important for the benefit of the humankind.
For the benefit only, not for exploiting the people.
Absolutely.
Thank you, sir. Ma'am. This is Isha. She is addressing question to ma'am.
Yes.
I would like to know that possibility of changes in field of trademark and copyright after COVID-19 era.
If you mean in the legislation, I don't think we really require any changes. I think we have excellent piece of legislation which is dealing with almost all aspects. So I don't think we really need changes in the legislation at all. And I don't know what kind of changes are you basically referring to, because if we have exclusive rights provision, we also have a fair dealing provision. We have compulsory licenses. We have 3 kinds of licenses which are given in the Copyright Act. Voluntary licenses are always there. We have statutory licenses. We've got compulsory licenses provision. So I don't think there's any need for amendment for the timing to deal with the pandemic situation.
There is another question from Pooja Sharma, madam. Pooja Sharma, and she is addressing sir and ma'am both. Could you please cover something related to IPR and climate change? How are they related?
Dr. Reddy, please.
See,
I think Dr. Pradeep, we need a separate session on it, because that's the WIPO's annual motto this time, and it's completely a different topic altogether.
Exactly, but I would like to remind the questioner about the patentable subject matter, etc., under Article 27 of the TRIPS Agreement, and environmental protection, which obviously covers even the issues relating to climate change, should be one of the exceptions to the patent protection. There you can see public health, morality, then environmental protection, so on and so forth. So that way, I think IP protection should not come in the way of dealing with the issues arising out of the climate change. Probably Professor Kulshrestha might answer for that.
WIPO is also saying innovate for the future. So, yes, please continue.
Can we take up last question of the day, sir?
Yes, Dr. Yadav.
There is a question from Gunjan Chawla, whether patent pooling for patents mitigate the threats posed by pandemics.
I think Professor Alka is the right person.
I think yes, in a way, because this is the time when we are not really looking for monopolies. We are rather looking for sharing of knowledge, so that whosoever is able to, work on anybody else's knowledge, that would become better. So I think so. Patent pooling is what even I think I am also suggesting, as many other academics are doing.
So with your permission, one more question is there. Alankrita Bomakanti. Ma'am, how
Yes.
should the users know what content is protected and to what limit they can use the content present on various platforms to avoid infringement?
Yes, that is a very difficult question. See, first of all, let me tell you, if you use anybody's content, first of all, under copyright law, registration is not important. So you get copyright automatically. So the moment anybody's work is there, you presume that the person who's prepared the work has copyright in it. How much you can use? The concept is that you can't substantially use somebody else's work. Little work for preparing another work, you can do so. You can, because in copyright, ideas are not protected, but the work is protected. And in work also, you will find there are, as I said, Section 52 of the Copyright Act deals with fair dealing provisions. And I think what is important for you is go through the fair dealing provisions. It will tell you what all you can do and what all you cannot do. It is very difficult for me to, tell you this is the content, this much you can take. But by and large, maybe 5% of some work, or even, but it depends. Like I said, if it's a song, if it's music, it may be just a split of a second. Like I said in Selfie Le Re, the song is a big song, maybe it's running into 6 minutes, but Selfie Le Re is just 3 words. That is the soul of the music, and that's the soul of the song. So that would amount to substantial copying, but in other words, in another song, picking up 3 words may not amount to substantial copying. So it all depends upon, I normally tell my students, I give them a test, which is, if you were the content owner, if you were the one who had created something, somebody uses your work, how would you feel? And how much of? Sometimes you're happy somebody's used your work to produce something else, right? But when they use it for their own benefit, then that is not a happy situation. Normally for fair dealing, there are 4 tests which are applied. So what you do is you first look at the purpose and the character of use. Why are you picking up somebody's work? What is your motive in that? Secondly, what is the nature of the copyright work that you're picking up? Third, what is the amount that you're using? And fourth is that what is the effect of picking up on the potential users of the copyright owner's work? All these things together, you will have to yourself assess and then make use of someone's work.
Yeah, may I add one sentence, Professor Yadav?
Yes, please.
Sir, please, sir, please, sir.
In fact, the content provider also mentions the extent of the work which can be used, how it can be used. For example, especially in the case of digital content, Creative Commons licenses, they
Yes.
clearly provide, what kind of use can be made, downloading or even transfer or even modify, so on and so forth. That is one aspect. Second thing is, with regard to the literary works, maybe in the form of research work, books, so on and so forth, we have to keep in mind some of the guidelines given by the UGC, guidelines on plagiarism. Then similarly, the use of the guidelines followed by, in fact, Turnitin also. Turnitin also clearly says, for example, we can less words on certain occasions suffice. Even paraphrasing one's own work also may amount to self-plagiarism. So, while agreeing totally with Professor Alka, I would like to, remind the questioner about the need to look at the terms of use as, stated by the content provider, then the terms of the license, then certain other provisions like I mentioned just now, maybe some kind of popular anti-plagiarism software or some of the UGC guidelines on academic integrity, depending on the context, please. Thank you.
Thank
As
you.
far as just one more thing that I want to add is all these UGC guidelines and the software for plagiarism, they are more for the academic and the education world. It may be creating a problem as far as your university is concerned, but it may not be a legal copyright infringement from the perspective of the Copyright Act. So we need to distinguish between plagiarism, which is a common word taken up by the universities, and copyright infringement. There may be plagiarism, but there may not be copyright infringement.
Yeah.
Thank you, ma'am. Thank you. Dear sir, with your permission, can I take a couple of questions? People have posted some more questions in chat box.
But already you have told 2 times is the last question. You should keep your words.
Yes, sir. For benefit of the participants.
Me, but I think Professor Reddy and Professor Chawla may have some other workouts. Because this topic is very interesting.
We can have another webinar, Professor Pradeep.
Yeah. Yes.
Okay, ma'am. I will take only 2 more questions.
Yes,
If
please.
you permit, ma'am. If you permit.
Okay.
Please go ahead.
Shailesh Surya, how can rural people aware about IPR and copyright in India? Because after COVID, when MSME will develop, then it will be a big challenge.
If you look at the national IPR policy, the first objective given in the national IPR policy is to have awareness programs. So the only way we can do it is have awareness programs. And I was thinking that when we had this, government started certain initiatives like Digital India and Make in India and Creative India, Innovative India. At that point of time, we did not know that all these initiatives of the government will come to our help. Because had Digital India not started, we would not have even reached where we are today in the pandemic times. Probably that's the only way. Awareness programs, that's the only way one can teach, no other way.
Thank you, ma'am. This is our last question of the session.
Yes.
It is Krishna Priya. How the patent and other IP laws could be shaped to meet the increasing demands of food for poor people? Can you please answer this question, please?
Food for poor people.
Yeah. How the patent and other IP laws could be shaped to meet the increasing demand of food for poor people?
In fact, maybe by strengthening the intellectual property rights, I like under the Plant Varieties Protection Act or Farmers' Rights Act, or maybe making the farmers' rights more effective. Certainly, we can increase the food product, and that will take care of the poor people. But here there is a very serious issue: intellectual property on the other hand, and human right on the other hand. Right to food is a human right. Now, another dimension is that even intellectual property also is a human right. That's what they say. It is not IPR versus human right, but IPR as a human right. I think what the Krishnapriya said is that IPR should be used for the purpose of protecting the human rights. And probably that can be ensured by making certain changes in the enactments like the Plant Varieties Protection Act, and the Patents Act will definitely take care of the larger public interest. Compulsory license, parallel imports, all those things be made, not only in respect of the pharmaceuticals and the drugs, but also in case of other patented inventions, including the food-related inventions. So probably I think that is some kind of reply. I don't know whether it really satisfies.
No, absolutely fine. I agree with Dr. Reddy, and to that we can even add traditional knowledge, the community rights that are being given. The IP cannot be the sole factor for poor. That's a very complex and a complicated issue, which needs to be taken from so many angles. What is their demand, education, transportation, so many things. IP would be a very small factor for dealing with it.
Thank you, madam. Thank you so much. Thank you, madam.
Thank you.
Sir, may I have the privilege of giving a vote of thanks? Please, sir.
Yeah, please.
I am very thankful to Dr. G.V. Reddy Garu. In spite of his very busy schedule, he was able to spare time for us and made us knowledgeable, give a good lecture on IPR. And I am very thankful to him. We will look forward to connect with you very soon for some other webinar also. And I am very thankful to Dr. Alka Chawla, Delhi University Associate Professor, that madam, you were able to spare the time for us for Sharda University. I am very thankful to you and for your valuable time you have given and the important knowledge you have shared with each one of us. Today our participants were more than 250 participants.
Always a pleasure. Thank you.
Yes. It is the respect people give you, both the speakers. Very thankful, ma'am. Very thank you, sir. Thank you so much. Thank you.
Alka ma'am, Lipika this side. Many thanks for this wonderful lecture. It took me back to my BU classes. Thank you so much, ma'am, for taking out time.
God bless you. God bless you.
Thank you, Reddy sir. Thanks a ton for sharing your wisdom.
Thank you, ma'am. Thank you so much. Thank you.
Ma'am, I'd like to add one line.
Yes, sir.
Good teachers, they teach. Great teacher like you and Professor Reddy, they inspire. And the way you have conducted today class.
You're always gracious.
Our privilege, sir. Thank you.
We are obliged.
Thank you.
Thank you very much, ma'am.
Thank you so much, sir. Thank you very much. Thank you, ma'am. Thanks a lot. Thank you, ma'am. Good day.
Yeah, thank you.